Calling the meeting to order. I'm Marty Castro, Chair of the U.S. Commission on Civil Rights, and I want to welcome everyone this morning to our briefing on racial disparities in the Stand Your Ground laws. It is currently 9:06 a.m. on October 17, 2014. I am joined today by Commissioners Achtenberg, Commissioner Narasaki, Commissioner Timmons-Goodson, Commissioner Yaki, and Commissioner Harriet. Commissioner Chladni and Commissioner Kurzenow will join us by phone. The purpose of this briefing is to determine whether there is a possible racial bias in the assertion, investigation, or enforcement of justifiable homicide laws in states with stand your ground provisions. Experts at this briefing will present testimony on the personal impact of the laws, findings from their research, especially those research pieces regarding the racial dimensions of justifiable homicides, and elaborate upon actions that are being taken by advocacy groups to alleviate concerns related to stand your ground laws. Now, stand your ground laws, some of us are part of a larger issue. We see what happened here in Florida. Other states obviously have similar situations. We see what's happened in Ferguson. Names like Trayvon Martin, Jordan Davis. These are now part of the national fabric of conversation about race and the impact about race. Whether laws are biased, implicitly biased, explicitly biased, those sorts of questions must be answered not by anecdote or example, but by concrete research. And it is our hope that the work that the U.S. Commission on Civil Rights is doing on this topic will present concrete statistical information, much of which is lacking in this area right now, to allow us to critically look at the true impact of these laws. Today we're going to hear from folks from different perspectives and different points of view. Our job here at the U.S. Commission on Civil Rights is to shine our historic light on these issues and separate the wheat from the chaff of what is being said and what is being produced on these topics and present to the President and Congress and the people of the United States our opinion based in over 50 years of advocacy and being a watchdog on civil rights as to what we believe to be the impact of these laws on minority individuals and minority communities. I want to thank Commissioner Yaki for his opportunity to bring this forward to us. I will ask him to make a very brief statement, and then I will introduce the members of the panel, and we'll begin our briefing. Commissioner Yaki.
Thank you very much, Mr. Chair, and thank everyone who is here today. I called for this investigation, and today, while it's just a briefing, it's part of a broader discussion and broader analysis by the Commission. This investigation today will help the investigation. It is by no means an end, but just a beginning of the analysis that will be conducted by our staff. I did so because about 2 years ago, I actually started calling for this investigation, and it wasn't until last year that the Commission had the resources and the personnel in order to start down this path. I did so because I'm troubled by stand your ground laws. I'm troubled by the fact that we have to have discussions about the deaths of African American men like Trayvon Martin and Jordan Davis. I'm troubled by conclusions and statistics showing racial disparity in the research of people like John Roman. I'm troubled by the expansion of a common law doctrine that now allows people not only to defend themselves in their home, but converts it into a shoot-first-anywhere policy. And I'm troubled by the fact that despite its claims, homicides seem to increase rather than decrease in states with stand-your-ground laws. And I'm especially, as a member of the U.S. Commission on Civil Rights, deeply troubled by the fact that here we are in the 21st century, and we are here to try to understand and study the implications, extent, and effect of bias, unconscious, implicit bias, and its impact on laws like Stand Your Ground. I hope today and in the days ahead that we will get evidence and hear data and collect information that can help policymakers, lawyers, judges, and others understand better these laws and their impact on our society. And I want to thank, again, everyone here today. I want to extend a special thanks to our staff director, Marlene Sallow, for working so diligently and hard on this matter with me, and again, I appreciate everything that she's done. Thank you very much, Mr. Chair.
Thank you, Commissioner Yaki. So now on to some housekeeping matters. So today's briefing is going to consist of a number of panels. Our first is going to be made up, all total 16 distinguished speakers. The first panel is going to consist of legislators and advocates. Panel 2 will consist of statistics behind the stand your ground laws and a guest advocate speaker that will give us a real-life perspective on the consequences of the implementation of stand your ground laws. And ultimately, Panel 3 with scholars giving us their perspective on this important topic. Now, during the briefing, each panelist will have 8 minutes to speak. After all the panelists have made their presentations, commissioners will then have an opportunity to ask questions of them. There will be an allotted time period for that to occur. As I have in the past, I will fairly recognize commissioners who wish to speak. Those commissioners who were unable to get here are on the phone. You'll have to shout out your name and let me know that you want to speak. Otherwise, the commissioners present, just raise your hand and I will keep a list of who will be next. So we also want everyone to adhere strictly to their time allotments so that we all have an opportunity to engage in a conversation on this important topic. You panelists will notice there's a series of warning lights that have been set up. When the light turns from green to yellow, that means you've got 2 minutes remaining. When the light turns red, I ask you to wrap up your statements and just be mindful of other panelists' time so we don't take away from anyone. I certainly don't want to cut off anyone mid-sentence. Again, I ask my fellow commissioners to be considerate of the panelists and one another and try to keep our questions and comments concise. I know there'll be follow-ups and I will allow that to a point, but we want to have everyone have the opportunity to ask questions. Once we do all this, I think we will have the data that we need. So what I'd like to do is first proceed with the panel that is before us now, our first panel. I'll introduce each of the panelists and I will swear you in. Our first panelist this morning is Chris Smith, Florida State Senator representing the 31st State Senate District. Our second panelist is Todd Rutherford, Minority Leader for the South Carolina State House representing South Carolina's 71st House District. And let's see, our third panelist is Ahmad Nabil Abuznaid, a Legal and Policy Director for Dream Defenders. And for the first panel, we were to have Lucia Macbeth, the mother of Jordan Davis. Unfortunately, she won't be able to join us today. She sends her sincere apologies and asks that her previously submitted statement be accepted for the record in lieu of her testimony, which we will do. So I will now ask the panelists to swear and affirm that the information that you are about to provide us is true and accurate to the best of your knowledge and belief. Is that correct?
Yes.
Okay,
yes.
Thank you. Senator Smith, please proceed.
Thank you, and I want to first welcome you to the Sunshine State of Florida. I appreciate you coming down here and having this very important grown-up discussion about stand your ground. And I, especially as a legislator who deals with the budget, really appreciate you coming to Florida. My district is 31st Senate District, which is Broward County, which is Fort Lauderdale, about 3 hours south of here, which is home of a lot of good shopping. So after this, feel free to track down I-95. I'll begin my remarks. In 2005, Florida passed the first stand your ground law, becoming in the process the national pioneer for all subsequent tragedies and unintended consequences that have followed. We have seen the law used by aggressors as a license to kill by allowing anyone to escalate minor disputes into a deadly incident, anyone to provoke a confrontation and then seek immunity under stand your ground, an escape hatch of fear of imminent bodily harm or death. While these provocations can occur anywhere at any time, aside from the most notorious cases, namely the Trayvon Martin case and the Jordan Davis case, other less well-known cases and incidents have occurred outside of family restaurants, bars, house parties, public parks, and as a result of road rage confrontations. Within weeks of the national uproar over the killing of Trayvon Martin in 2012, I convened a task force of prosecutors, defense attorneys, law enforcement personnel, and scholars to review the law and make recommendations for legislative changes. My task force issued a report and recommendations in May of 2012. Among the things my task force recommended were education of the public and law enforcement officers on the Stand Your Ground law. 2, creation of a system to track self-defense claims in Florida so we could identify any desperate treatment. 3, allowing police to fully investigate all killings by detaining suspects, even when they claim stand your ground immunity. 4, defining the term unlawful activity and clarification of the role of provocation, thus allowing the law exactly when people are aggressors, such as that when people are aggressors, they should not be able to hide behind stand your ground after taking a life. The governor of Florida convened a task force, and they also recommended that the legislature examine the term unlawful activity as to give guidance to courts on the proper application of the law with the intent to protect innocent persons. The governor's task force also agreed with my recommendations to educate law enforcement agencies, prosecutors, and judiciary on self-defense laws, and to review the standards regulating neighborhood watch associations. Despite the recommendations by my task force and the governor, the legislature only looked at 2 of the recommendations: removal of immunity from injuries and deaths of an innocent third party, and a review of 1020 life minimum mandatory in a narrow scope of cases involving stand your ground. At this time, the state still refuses to compile a comprehensive database of cases. Luckily, the Tampa Bay Times, the Urban Institute, and the American Bar Association and others have, and data shows disturbing disparity involving the impact of this law, which remains bewildering to law enforcement, confusing to prosecutors, and misapplied by courts. I noticed on your agenda that you have persons discussing the statistics, and so I would not go through those statistics. Just a recap that the overwhelming statistics show that it's the race of the victim which is most dispositive of the outcome of the cases. When the victim is black, there are huge statistics showing that you're more likely to proceed with a stand your ground defense. This year, I filed a bill, a bipartisan bill, which did 4 of the things in which I discussed. It clarified the definition of aggressor and made clear that people who start fights and chase victims down cannot later claim immunity or self-defense under stand your ground. It provided guidance to judges and juries about the legislative intent of the law, and it placed guidelines on neighborhood watch programs and allowed innocent bystanders to file lawsuits to recover injuries. Even though the bill passed 2 committees, it was later blocked from the Senate floor. Still, I provided the legislature with yet another opportunity to right the wrongs of this law. I proposed a simple, common-sense amendment to a bill being considered on the floor of the Senate. My amendment would have specified the how, when, and by whom of using the statute's defense. It would have defined aggressor, stopped those who start and bring themselves to a deadly fight from hiding behind the law's protections. It would have simply added a bipartisan statement of legislative intent, which would finally give notice to the public and guidance to judges and juries about what the legislature meant to achieve with stand your ground statute. My amendment would have clarified that justification and immunity protections in the statute were not meant to shield aggressors, vigilantes, and others, and condoned other acts of revenge. Yet the Senate rejected these concepts. My amendment was rejected along party line votes, with the majority party prevailing. Over and over, some legislators have disingenuously said that tragic outcome was not the intent when we passed stand your ground. But that is cold comfort to anyone who has lost a family member to a senseless violence inspired in part by a perpetrator's belief that this law gives them absolute right to take a life and provide them immunity after doing it. Adding insult to injury, when given the opportunity to clearly outline in statute what exactly they meant when they passed the statute, some of my colleagues turned their backs on the opportunity, and in doing so, turned their backs on many youth who tend to be victims of this egregious abuse of the immunities and defenses contained in the current law. Notably, the one thing the legislature did do this session was to expand stand your ground, cynically invoking the case of Marissa Alexander to justify broadening the flawed law. Purportedly, the purpose of the new expanded language was to help protect a person who fires a warning shot in circumstances where they would be free to use stand your ground to injure or kill someone. It provides that such a person cannot be prosecuted. However, the new language goes further and does much more. It allows stand your ground claimants to have their records expunged if their charges are later dropped or if they prevail in court. This will make it virtually impossible for the public to effectively track these incidents and thereby use the data to demonstrate desperate impact of the law.
Thank you, Senator. I appreciate your presentation. Representative Rutherford, you have the floor.
Thank you, and good morning, and thank you for inviting me, and I apologize. I seem to have lost my tie in transit, didn't realize it until this morning when I was coming over. And I do want to state, first and foremost, that while I am one of the legislators that voted for the Stand Your Ground law in South Carolina and continue to be one of its proponents, I am interested in the conversation and the dialogue this morning as to whether any changes can be made to make it any better. In South Carolina, I do believe that it will remain the law of the land, that it is not going anywhere anytime soon. And as a lawyer, I have used Stand Your Ground successfully in one case and have another hearing coming up in November, and recently used it this week in another case, and have not seen the data to suggest that there's a disparate impact on African Americans, although I'm very interested in Senator Smith's data and how we can look at that and make sure that that is not going on. I will not remain a proponent of a law that clearly has a disparate impact on African Americans, although it has not been shown to me that that is the case currently in South Carolina. The last case that I tried was the state of South Carolina versus Shannon Scott. It deals with one of the instances that Senator Smith brought about. My client was charged with, when he was at home, he received a phone call from his daughter who was being chased home from a nightclub by some female thugs. They chased her all the way to her house. He had his daughter pull in the backyard. When he did, the female thugs out front fired a warning shot. They turned around at the end of the street, cut off their headlights, and as they were approaching his house again, he requested that they please stop. He fired a shot, and that shot hit a second car that was following the female thugs and killed a 15-year-old individual in that car. My client was charged with murder for the death of the 15-year-old child. It was a senseless tragedy that never should have happened, but one that could have been prevented, A, by the female thugs never following his daughter home, and B, by the police arresting the female thugs and charging them with felony murder as would be allowed in South Carolina. No clue why that did not happen, and on the stand, the police, when confronted with why they did not arrest them, said, "I don't know." And so an innocent person shot, clearly the wrong person shot, but my client, Shannon Scott, simply defending his home, his castle, and his family, who were cowering on the floor in the kitchen, trying not to get shot. The one this week was an individual who was at home, and some people tried to do a home invasion on his house, beating on his door with a sledgehammer. They beat on it 3 different times, as confirmed by witnesses across the street. He opened the door, did not realize that someone had tried to get in until he saw the marks on the door. He then went to leave his apartment. In doing so, he was confronted by an individual with a gun, the other gentleman with the sledgehammer who he thought had a gun. The individual pointed his gun at him. My client exited his vehicle, fired several shots, one of whom hit the gentleman with the sledgehammer. He was not prosecuted, is going to do a statement to the police, and will receive immunity under the Stand Your Ground law for that case. The next one in November is an 18-year-old, he's a 17-year-old child at the time, was at a restaurant, fast food place after a basketball game. Because it was a basketball game with rival teams, there were several words being thrown back and forth in the restaurant. My client leaves the restaurant, goes and gets in his vehicle, and as he is leaving the restaurant, is approached by another kid, because these are 17-year-olds, who comes up to his window, and the allegation is that the victim, in this case of the person that was stabbed, reached in the window, tried to grab my client, and certainly put him in fear for his life. My client reached out the window with his knife, the knife that his grandfather had given him, and he stabbed him one time, cut off the bottom of his heart, and the victim died within the next 5 minutes. Tragic cases in every single instance, but cases that in South Carolina would have left an African-American male charged with a murder charge that they would probably not be able to defend financially, that would have left them in jail in South Carolina typically for a year, 2 years before they would have ever gone to trial. And having the ability to use the self-defense case law. South Carolina does not have a self-defense statute prior to Stand Your Ground, so you would have had to have relied on case law, which suggests that you must retreat, that you cannot elevate the use of force, which in most instances is troubling in and of itself, but certainly in these cases, it would have led to the most recent client, the child at the basketball game, because he used a knife on someone who was unarmed, not able to avail himself of the self-defense law. It has been my opinion since I saw the proposal for Stand Your Ground that the old law, the old case law as it related to self-defense was outdated, that people should not have to live in fear, that you should not have to measure your use of force by that which is being used against you, that it was archaic, and that it continues to be. I am troubled by the fact that someone could act as a vigilante, but I do believe that the courts, at least in South Carolina thus far, have rooted those cases out. I'm troubled by the fact that someone could be a wrongdoer and claim that he was lawfully someplace where he should not have been. That case came up in South Carolina. A gentleman that was in the middle of a home invasion tried to claim that he was forced to do the home invasion, and when he shot the homeowner, that he deserved immunity under Stand Your Ground. The judge laughed at it, sent it up to the Supreme Court, and the Supreme Court tossed it out. I am told by a number of lawyers who have not given me permission to use their client's name or their fact scenarios, but that there are several other cases pending in South Carolina with African-American defendants who shot white individuals who were the wrongdoers, who are seeking to claim Stand Your Ground as an immunity defense, but have not been able to do so because they simply cannot get a hearing. It is the evidence that I have seen in South Carolina, the anecdotal evidence, has been that it is more used by African-American defendants than it is by white defendants. I can tell you that I watch the news as everyone else, and I'm concerned about the Trayvon Martin case, about all the cases in Florida that seem to be going in the wrong direction. But I don't know that I've seen one where the Stand Your Ground law was used successfully and used in an immunity hearing in such a way as to create a disparate impact. I welcome that data, and as you all, once I get that data, if there's a change that can be made in the law, I'd seek to do it. So, thank you.
Thank you, Representative Rutherford. Next, we would like Mr. Abuznaid to present.
Thank you. Thank you to the Commission for convening this initiative. We are extremely excited for the future results. I'm here representing the Dream Defenders, a youth-based human rights organization in Miami, Florida. Our organization was created in response to the tragic killing of Trayvon Martin. A national and international dialogue has been brewing around the harmfulness of Stand Your Ground laws, also known by many as Shoot First laws, and their implications for the right to life, non-discrimination, and equality before the law. These Stand Your Ground laws have, in a sense, legalized the devaluing and dehumanizing of minority lives in a very real way. We have recently heard from the members of the United Nations Human Rights Committee that Stand Your Ground laws are incompatible with the right to life. We have also heard great concern from the Inter-American Commission on Human Rights regarding many of these tragedies. It is imperative that the federal government ensures that state and local governments do not promulgate laws that violate rights as fundamental as the right to life and equality before the law. Stand your ground laws amount to state complicity in the perpetuation of violence by its citizens. Furthermore, our society has a long history of racial discrimination and a system that, to put it mildly, has never been kind to its black and brown minorities. Since we understand that the system itself has had to be constantly revised to deal with its inadequacies related to minorities, it should come as no shock that a law allowing vigilantes to use fatal force on the streets would disproportionately affect minorities. Obvious history and notions aside, research has shown that stand your ground laws are dangerous in terms of increasing levels of homicide and are discriminatory in their application as to race and gender. Statistics based on a database compiled by the Tampa Bay Times of SYG cases in Florida since the passage of the law show that a defendant who killed a white person was more likely to be convicted of a crime than a defendant who killed a black person. White-on-black homicides are 250% more likely to be found justified than one-on-white homicides in stand your ground states. This disparity increases to 354% in stand your ground states. Moreover, the Urban Institute's Justice Policy Center conducted a study using the FBI's Supplementary Homicide Report for 2005 until 2009 and determined that less than 2% of homicides are eventually ruled to have been committed in self-defense. That number contains a significant split between stand your ground and non-stand your ground states. Women have also been disproportionately impacted by stand your ground, especially those dealing with domestic violence. Florida has been home to the tragic handling of Marissa Alexander's case. In a recent analysis of FBI homicide data prepared by the Urban Institute, comparing stand your ground and non-stand your ground states, and examining the use of stand your ground laws in case involving women defendants, 13.5% of cases where a white woman killed a black man were found justified, whereas in contrast, only 2.9% of cases where a black woman killed a white man were found justified. Again, this highlights the disproportionate role that race plays in justifiable homicides and how that is overlaid in cases involving women defendants. The data also revealed that such laws introduce bias against black victims and in favor of white defendants. In cases where the defendant was black and the victim was white, there was little difference between the stand your ground states and other states. However, when the defendant was white and the victim was black, 16.85% of the homicides were ruled justified in stand your ground states and only 9.15% in non-stand your ground states. Even worse, blanket immunity and broad discretion to law enforcement offered by Florida-type stand your ground laws infringe on victims' access to courts and their right to a remedy. The more recent case involving the murder of Jordan Davis and the jury's deadlock on his murder count exposed just how much confusion stand your ground has introduced into the criminal process. It took a second trial and jury to convict a man of a murder everyone knew he committed. Why did the jury find trouble with the decision? Stand your ground laws, of course, because they allow for subjective biases, implicit biases to guide decision-making that could later be fortified by law. Sadly, most victims and or their families will never receive justice, and worst off, they will have to live without their loved ones for the rest of their lives, all because someone thought they looked suspicious while walking through their father's neighborhood, or they disturbed someone's movie experience while texting a babysitter. As you may know, some of the most high-profile tragedies we have witnessed in Stand Your Ground have occurred here in Florida. We have been the first state to enact such a law, and Florida should be the first state to repeal such a law. The federal government must support such a repeal. The federal government must step in to condition funding to states based on its ability to guarantee equal protection to all of its citizens and elimination of laws that hinder their ability to fulfill that duty. On the ground here in Florida, groups like the Dream Defenders, Community Justice Project, Power U, and others have been rallying around communities concerned about that very protection of our lives, which Stand Your Ground stands in the way of. Unfortunately, the people's call for a repeal has been ignored by the Florida legislature. Not only that, but more legislation being sent down the pipelines to gun us down, including a so-called warning shot bill whose advocates propelled it forward under the guise of support for Marissa Alexander. But these lawmakers have shown that they don't care about Marissa, they don't care about Trayvon, Jordan, or our communities. Florida and other states are currently looking at laws that would arm school teachers with guns, and I would postulate that it would not be long before one of our teachers stands their ground against one of our kids. We are not safe in our streets, our neighborhoods, gas stations, movie theaters, and soon to be schools. Thank you.
Thank you. At this point in time, I'd like to encourage commissioners to begin to ask questions. I'll cede the floor to Commissioner Yaki to begin, and then just identify for me. Okay, we'll keep a list.
Thank you very much, Mr. Chair. This goes to all three panelists. I was struck by the notion of due process, and I think especially for Mr. Rutherford, who's a lawyer as well, the issue of due process, I think, is very important in Stand Your Ground from a number of different factors, but especially from the standpoint of the person who may be the victim of a Stand Your Ground defense. That person may be injured, that person may be dead. And and not being able to present his or her side of the story, you've essentially ceded the authority to be judge, jury, and for lack of a better word, executioner to the person asserting that. And I guess the question I'm asking is, if you were confronted with a statistic, a scientific fact, that the research shows that people are more likely to act in a certain way based on unconscious racial stereotypes they may have within them. I mean, we're not talking about someone who says, I'm a racist, I hate, blankly blank or blank blank. I'm talking about the studies that show that if you give a test to people, there's a disparity in how people judge people based on what they look like. It doesn't matter if they claim themselves to be racist or not. But the most current example is the fact that if you talk about voter ID law to a white voter, but if you accompany that image with the image of a black person at the voting poll, support for a voter ID law shoots up well beyond the statistical range. By the same token, when you have these tests that test for implicit bias, a black person is much more likely to be shot by someone much more than a white person in these tests, based on the fact that it's this unconscious bias in their system. So I'm just asking, when you have a law like Stand Your Ground, which has in it essentially for lack of a better word, a trigger component in it to say, I have to make a decision right here and right now, what am I going to do? And if there's a built-in bias against finding for not shooting against a white person and for shooting against a black person, how do you reconcile that as a legislator and a policymaker?
Commissioner, thank you for that question. And I can tell you that as a black man who grew up in South Carolina, I am well aware of implicit bias. And as the lawyer for the gentleman that most recently in South Carolina, LeVar Jones, who was shot by the trooper while simply reaching for his wallet, a trooper who I've known for 10 years, I can tell you that I understand also how implicit bias comes into play. In that particular case, Mr. Jones was requested by the trooper to get his ID. He patted his back pocket. Not finding it there, he turned to go into the car, and Trooper Gruber from South Carolina Highway Patrol shot at him 4 times, hitting him once in the hip. The most troubling part was Trooper Gruber's statement afterwards, where he defined or tried to define Mr. Jones as being an aggressor, that he aggressively went into his car, that he aggressively approached him, none of which was indicated on the video, but all of which, absent the video, would have been enough to clear Trooper Gruber. Troubling because I still see members of the South Carolina Highway Patrol when I go to court who talk about race and that Trooper Gruber was not a racist. And they missed the point that he would not have done that if it were not a black male who looked unlike Trooper Gruber, who did something that Trooper Gruber in his mind may have believed to be aggressive because he was simply following his commands. I, like Attorney General Holder, was walking in Georgetown when I was in college, and a cop walked up to me and placed his baton in my chest and told me to cross the street. I said, why? And he hit me again with the baton and told me to cross the street. And I crossed the street. This was in 1989. This is not the 60s. I'm well aware of the bias that goes on, but I also see the bias in the judicial system. I listen to the statistics that are given and well aware that a white defendant in a stand your ground case may have a better ability to hire a lawyer to assert his stand your ground rights than an African American defendant. That, as my client this week with the stand your ground hearing, he was able financially to bring me to the scene to talk to law enforcement at the scene, to detail for them how this happened, and to mention stand your ground to law enforcement before an arrest was ever made. And I know that implicit bias and racism run rampant throughout the judicial system, especially in South Carolina. It cannot be taken out of the system in one fell swoop, and to suggest that by myself or any other proponent of stand your ground is simply ridiculous. I would be curious to know within the statistics how much racism as a whole played into the impact in the end. And that means that the law enforcement officer didn't care that stand your ground laws existed. There was a black person with a gun and a dead white person. He was simply going to arrest them anyway and ignore stand your ground, which I have had happen as well. Stand your ground the way that I intended when I voted for it, the way that I stand behind it as a proponent, is meant so that people do not have to live in fear, that you don't have to walk down the street with your children and someone intends you harm and you would have to retreat back to the furthest place. You could not elevate force. You could not do any of those things which, to me, negate common sense. Now, in saying that about common sense, I again use common sense and apply the fact that racism is rampant in our system and I don't know how to take it out. Implicit bias is rampant in our system and I don't know how to take it out. But in a situation where an individual is using the law, and the law as it is currently written, in my cases, African Americans, in some cases, wrongfully used by white Americans, but simply using the law as it is written, judges are supposed to determine, without the implicit bias, without the built-in racisms that are in the system, are supposed to determine that someone is immune from prosecution. They are supposed to be the ones to determine reasonableness. If they're not doing their jobs in South Carolina, we would look to remove them. But I don't know how to take that out of the system without taking out the ability of other persons to defend themselves.
Senator Smith?
If I can, 2 points. When you talked about due process, looking at the Florida law, I haven't looked at the South Carolina law. Due process also involves the officer on the scene. The Florida law is so ambiguous that it's not a judge making the determination. It's an officer on the scene, because the way the law is written, it says a person cannot be arrested, and in the arrest definition, it says detained. So the Florida law is so ambiguous that an officer coming up on a scene in a park with a dead person and a person holding a gun that says, I'm invoking stand your ground, realistically, that officer cannot detain that person, thus do a full investigation. We saw it play out in the Trayvon Martin case, where the officers were confused as to whether we can even detain Mr. Zimmerman. And so when you talk about due process, that is a major problem in Florida. We're not even getting to judges. We're not getting to juries. Officers on the scene are told within the law that we've tried to change, they cannot arrest, and arrest is defined as detaining also. And secondly, I noticed in all the paperwork, and I just heard it, one of my pet peeves when discussing stand your ground is when anyone mentioned retreat today. Remember, Florida law, and I'm unsure of other laws, always had a word that everyone neglects. It said safely retreat. Prior to 2005, we had self-defense in Florida that's often ignored. The Florida law has always been you had a duty to safely retreat. There wasn't a turn and run portion of the Florida law. It always had safely retreat, which is ignored. So please, as people discuss the Florida law today, keep that in mind. Prior to 2005, it had the word safely retreat. There was never a concern of you having to run away from someone attacking you in public.
If I may add, I think Senator Smith definitely contributed a couple very important points, but I also wanted to add that while it's important that people shouldn't have to live in fear, due to stand your ground, others have to live in fear now. And also looking at fear and breaking down fear and finding that a lot of times the fear is unfounded. With Michael Dunn, it was because hip-hop music was blaring from the car, and Jordan Davis and his friends seemed to be like thugs to Michael Dunn. And, you know, to George Zimmerman, Trayvon Martin seemed suspicious because he had an implicit fear of black men in hoodies. And so I think that people should not have to live in fear. However, we should navigate that fear a little bit deeper and figure out where it comes from. You know, the fact is that if we're going to allow for, you know, vigilantes to not be afraid, then those of us minorities who are often viewed as threats by society might start being very afraid of walking around our neighborhoods.
Before I give the floor to Commissioner Narasaki, I actually have a question. We really have been talking about this issue, and it is talked about in a black-white binary for the most part. Is there anything each of you might be able to shed light on in terms of the impact on Latinos when the stand your ground laws are used?
If I can, Mr. Chair, it's, and part of my introduction, I talked about the lack of statistics. We can only go by what's been reported and say the St. Pete Times and those others. That's part of the problem. We don't keep actual statistics about black, white, and Latino. A lot of times when looking at it, you can only go by if it was said that this was a black male. It doesn't say this was a Hispanic male. And so it's hard to really give you a definitive answer. And that was part of the concern that we have in Florida, is actually keeping statistics, because part of what we propose is that if an officer comes up on the scene in Hialeah, and it's involving a Latino and someone else, and that officer determines this is a stand your ground case, they go home. We wanted to make that officer keep actual record that stand your ground, victim, aggressor, and perpetrator, or however, so that you can come back in 2 or 3 years and discuss that. So as you look at these laws, please look at, it's hard to really answer your question without anecdotally looking at facts, because in a lot of these states, we don't require officers or judges or prosecutors to keep actual statistics that you can look at empirically in a year or two to determine that.
I would also like to add that oftentimes, you know, who's categorized as white, Latino, Hispanic, Arab, Muslim has a great weight in factors. If you look at the Department of Corrections, you'll look down in the list of inmates, you'll see all types of Muhammad, Ahmed, all that, and then it says white. So I think sometimes, you know, the way people are labeled has a great deal with our ability to keep these statistics.
I've not seen that data in South Carolina, and certainly would be interested in looking at making judges and law enforcement officers keep that data to see whether there is a disparate impact on Hispanic males or Hispanics as a class.
Thank you. Commissioner Narasaki?
Thank you, Mr. Chair. I want to thank Minority Leader Rutherford for sharing the stories of his clients. It shows how tragic all these situations are. I have 2 questions, though. One is, does South Carolina law also include, like Florida, immunity from civil liability? And if so, what should the rights of the family who's lost a loved one who was an innocent bystander in that situation, if there is immunity from civil liability, because there's more than one victim in that case? And the second is, it sounds like you do support data collection. Would you support the federal government tying funding for federal criminal justice funding to requiring states to set up sufficient reporting systems?
I'll answer the second question first and say absolutely. The collection of data is essential to the understanding of any law and its impact. And in these cases, especially so, because like I said, in South Carolina, I have not seen what I've seen in Florida. I could not stand here as a lawyer and a proponent of justice and look at what goes on in Florida and act like it's okay. The first question is, and I'm losing the first question.
Civil liability.
All right, yes. South Carolina, the stand your ground laws came out of a conservative group that sent the law to South Carolina. We looked at it, we passed it. It mirrors Florida's law. In fact, our case law in South Carolina initially came from Florida as the Supreme Court looked at how to deal with stand your ground cases. It not only offers civil immunity, it also allows for the return of attorney's fees if someone is sued after they are found immune from prosecution under a stand your ground case. As to the victims and what the victims can do, the problem gets to if you have a situation where someone has truly availed themselves of the stand your ground law, which is difficult to determine. And I say that because if a law enforcement officer comes out to the scene and believes that an individual used self-defense, that law enforcement officer, who's typically an investigator at that level making that determination, not just a line officer, but somebody that has hopefully years of experience, that person is determining that the individual, the perpetrator in this case, because there's a shooting or a stabbing or whatever, it's the person that took the life. So I don't want to call them the victim, but the law enforcement officer may consider them to be the victim, that he is determining that they didn't do anything wrong or that they simply acted in self-defense. Because stand your ground is somewhat an articulation of self-defense. In doing so, stand your ground says they are not to be detained, they are not to be arrested, which some people take, well, they're not investigated. Well, I disagree. I think that an investigator should, at least in South Carolina, an investigator would investigate a murder case, not just a line officer. That investigator determines that this person used self-defense, that they can articulate that they had a lawful right to be where they were, that they had a reasonable fear for their life, and that they acted on that fear and that belief. The investigator determines that they are clear and he's not going to detain or arrest them, which under self-defense he should not have done anyway. But South Carolina, as I stated before, had no self-defense law. It was based on case law. So in order for an individual to be cleared in South Carolina, they would have had to have been charged with murder or charged with whatever the offense was.
I'm actually, though, I'm not focused on the criminal process. I think I'm focused on the civil liability, which, as you all know, it's a different standard. And the question here is I'm not focusing on whether the person who felt fear, what he did versus the person who was causing the fear. I'm talking about the innocent bystanders who had nothing to do with either side of the equation, who nonetheless lost their life. So what is the recompense for them?
The recompense for them...
And are you concerned that this stand your ground law could in fact create a huge public safety issue, because now you're not talking about someone who's close to their home, but you're talking about someone who could be in a crowd wildly shooting? Is that something that you feel comfortable with? And if there's no civil liability, do you feel like there might be a tendency for more of that to happen?
No, ma'am, and the reason why I say that and where I was going is that because on a lot of these cases, those where no one is arrested or detained, there's not going to be enough information out there for a civil case. But 9 times out of 10, and I'd venture to say 99 times out of 100, for innocent victims, for victims in these cases, there's not going to be any recompense on a civil basis anyway. Rarely could you find insurance to cover someone that was involved in a stand your ground case. And for the innocent victim, and there's a perfect case on that in South Carolina, an individual who was a convicted felon was in an entertainment district. Another individual walked up and pulled a weapon, clear on video. The second individual pulled his gun, shot at the guy that was pulling the gun, and hit and paralyzed a University of South Carolina student. The shooter in that case would have been able to avail himself of the stand your ground law, because it was clear on video that he was reacting to someone else pulling a gun. He was a convicted felon. He did not have a right to possess a firearm, and the federal government gave him 23 years in prison. And so that's how they dealt with that case. But would he have, if he had shot, as he did, and paralyzed someone, would they be able to sue him? wouldn't have any assets for them to be able to sue him
Yes,
anyway.
but we're talking about, in your case, your client had a house.
Right. So, well, he rented the house, and so there was no insurance.
I think, the issue about whether they would have actually had money or not is not the question I'm asking. The question is, should there be some kind of recognition in the law that something happened to someone who is an innocent bystander?
I believe that.
Thank you.
Thank you. And yes, to answer that question succinctly, an innocent bystander who is shot can always sue. Whether they could ever collect is a different story. Even under this, they could sue someone that was cleared because, well, when you say innocent, it gets dicey. And the short answer is, I don't know.
Representative? Senator?
If I can, I think the Florida law clearly says immunity even from civil liability. So, and I guess in your scenario, even in your scenario, if a person negligently is defending themselves and then just sprays the room or something, that in Florida, even though they were negligent and just spraying a room, they're immune from civil liability even though they were highly negligent, as long as they claim stand your ground. And I think that is a concern. I don't know if your statute is that specific.
The statute is that specific, but I disagree. I don't think you could negligently spray a room. I think if you're spraying a room, you're not going to be cleared. You should not be cleared under the statute by stand your ground. That's not defending yourself. That's negligently spraying a room. And there's a difference. So if someone can show me the case where someone is clearly defending themselves and found immune from prosecution by understand your ground and should be sued, I'd love to look at it. But you can't negligently spray a room and claim stand your ground. That's not the same
There's
thing.
a Miami case in which it happened, a drive-by shooting, and a 3-year-old sitting on her porch. The young man was defending himself, understand your ground, and when he shot at the guy shooting at him, he hit a 3-year-old sitting on her porch. He's immune from civil liability. We're not talking about the criminal case. We're talking about civil liability. So her family could not sue that perpetrator, even though he may be judgment-proof because he's broke. There still is a civil immunity from going after that person who shot.
But as tragic as it is, that 3-year-old's parents should not be suing him. They should be suing the people in the car that were shooting at him. That's what stand your ground says. And to take that to its logical conclusion,
That's what we're talking
the suggestion is that the individual that was being shot at should what? Get shot? Should not be able to defend themselves? The civil liability for that 3-year-old, for those parents of that 3-year-old, goes against the initial people that started the shooting, not against the person that unfortunately and tragically took the life of their 3-year-old. So liability would extend not to the person that did the shooting, but to the person that caused the shooting to take place. So yes, the person that did the actual shooting would be immune, but the person that caused the shooting, absent a collection, absent being able to do so, should be the one that is sued. So they are not blocked from civil liability. The civil liability is taken from the person that is found immune and extended to the person that actually caused this to transpire in the first place. In the case that I just mentioned in the entertainment district, it would be that they would sue the person that pulled the gun. In the case that I talked about initially, where the people were in their home, they would sue the girls in the car. If all these people are rich and understand that you have to have the ability to pay, but in the 17-year-old's case, there would be they would have nobody to sue because their child was simply involved and it's a one-on-one situation. But anytime you've got an innocent person who is hit, someone not involved in whatever is going on, that person's civil action is against the wrongdoer, not the person that is found immune.
Senator, did you want to add something? It looked like you were.
Well, I guess I'm a little confused. The wrongdoer, even if when I gave the scenario, the person doing the shooting from the car, and I understand under the representative's scenario, the person who initiated it and caused the incident to happen should be the person liable. But if the person that actually doing the shooting, even though they're defending themselves, if they defend themselves in a negligent manner, under the case law, they're immune from even in the case of negligent, they're immune from civil liability.
Yes, sir. And this is where this came up, and this is prior to stand your ground, and it came up several times in the case that I tried with the 15-year-old deceased victim. If someone robs a store and the store owner has a gun and he pulls the gun to defend himself, and he accidentally hits someone else in the store, do we say that store owners should not have guns to protect themselves? Do we mandate that the police always shoot straight? Do we take guns from police officers who mistakenly hit innocent victims? The answer is that the wrongdoer, the person that is causing the problem in the first place, is the one that is subjected to civil liability and criminal liability. That's the way that it should go. I understand that under Stand Your Ground, we have an issue of whether this person is actually the wrongdoer, and that's the bigger issue. But as it relates to civil liability, the civil liability goes to the person that created the wrong in the first place. You can't say that someone negligently shot if the only reason why they shot is because they were being shot at. You can't mandate that in the case that I just mentioned with the South Carolina trooper, at point blank range, he fired at my client 4 times. He hit him once in the hip and just barely on the side. He almost missed him that time too, 4 times point blank range. You don't mandate that people shoot straight. You would hope that they would not have to shoot at all. And Stand Your Ground, in my opinion, suggests that I have a right to defend myself, and I should not fear defending myself that later on someone's going to say, well, you should have shot better. And that was actually the testimony from the police officer as to why he arrested my client. He said he should have been a better shot. That's not the law. That ain't the law for police officers. It's not the law for individuals. The law says I have a right to be clear, to free myself from thugs, from people that intend to do me harm. And then if I defend myself, I should not be sued, nor should I be arrested, detained, or prosecuted because of it. I'm expensive. And if someone is arrested or detained and they have to hire me to defend them, they have spent a lot of money doing so. And in doing so, and they are eventually found immune from prosecution, what the system has said is that you were wronged. You were wronged by police officers who may have seen you as a black man who killed a white person, who they didn't want to find you immune at the scene, so they arrested you. They made you go through this trial. That's wrong. And that happens. We can't take racism out of the system. But we can't also sit here and act like situations don't occur, and they will continue to, where someone defends themselves and then finds themselves placed in a position where they have to avail themselves of the Stand Your Ground law. And once they do so, civil liability is there, it is clear, and it goes against the wrongdoer, the perpetrator, not the person that defended themselves.
Every accident is not negligence, and I concede that. And Representative Rutherford, you keep talking about accident, and I concede you don't have to be a perfect shot. But there are times when people are negligent. If it's an accident where your store owner, if he accidentally shoots someone, you must agree that all accidents are not negligence. We're talking about in cases where there's true negligence.
I think by definition, accidents are negligent, because if it's not negligent, then it's intentional. So you're only getting situations where someone either negligently did something or they intentionally did something. You can do reckless. Reckless is they did it negligently, but they should have known better. Someone that gets in an accident for speeding on a highway, they're going 10 miles over the speed limit, that's negligence. They're going 100 miles over the speed limit, that's reckless, and there's a difference.
Well, I stand corrected. Even in reckless in Florida, you're still immune.
But again, if the reckless act was brought on simply by the person doing a wrong act, meaning that my recklessness, I'm firing because this person shot a gun at me, we're not going to go back in South Carolina, and I doubt Florida will either, and say that when you are fired upon, you can only fire one shot, and that shot must be at the upper torso or at the head. That's not the law. The wrongdoing is the person that caused this person to fire a shot. In the Trayvon Martin case, and I've said this repeatedly, what would have been interesting in Florida is if Trayvon Martin would have shot George Zimmerman and tried to avail himself of Stand Your Ground and was denied that by law enforcement and then by a judge. That's what would have been interesting, whether a black man in a hoodie could avail themselves of Stand Your Ground. That's a test of the law. That's a test of the law. What George Zimmerman did not use your Stand Your Ground. He simply said, I'm white, he's black, self-defense. People found that. But if Trayvon Martin would have shot George Zimmerman, that's a test of the law. It's 5 points. The entertainment district shooting where the young lady was paralyzed, that gentleman's family called me. And I knew that it was a Stand Your Ground case. I did not know that he was a convicted felon. That was going to be a test case in South Carolina as to whether they truly have the backbone to support when an individual that we know society, whether he's Latino or African American, has shot someone, an innocent white woman who's now paralyzed, whether he's going to be able to use a stand your ground defense. They were able to skirt that by letting the federal government take it over, but that's a test of the law. That's a test of the law.
Before we go on to Commissioner Achtenberg, actually, Commissioner Yaki has an article here that is germane to the colloquy that was going on here. Commissioner Yaki, then we'll go to Commissioner Achtenberg, and then no, I know I've got a list here. It's Achtenberg, then Chimmons Goodson, and then Gale.
No, I just wanted to point out that cutting through all of this is that a South Carolina judge has interpreted the statute to be identical to Florida and to grant civil immunity to an individual who in exercising his or her stand your ground rights, shot and killed an innocent bystander. I just wanted to put that on the record.
Right, that was my case.
Okay. Commissioner Achtenberg, then Commissioner Timmons Goodson, then Commissioner Harriet. And do any of the commissioners on the phone want to indicate an opportunity to ask a question?
Mr. Chair, this is Kirsten. Now, I may have one question.
Okay, I'll have you after Commissioner Harriet. Commissioner Achtenberg?
Thank you, Mr. Chairman. Senator Smith, I have many grave concerns about the Florida version of the Stand Your Ground law, the most significant of which is the interjecting of complete subjectivity into the self-defense law of Florida. And by that I mean what used to be an objective standard, whether or not it was a reasonable person would have perceived the threat sufficiently to warrant his or her response with deadly force, not whether or not a person with a thin-skinned plaintiff or what have you, but whether or not this person perceived that they were in danger of being having deadly force used against them, they responded preemptively and in kind. Can you explain the rationales being offered at the time that this revolutionary statute was adopted by the Florida legislature? Was there a precipitating event that encouraged the legislature to throw out 100 years of common law and to change the paradigm such that implicit bias is then baked into the system? We talked before about the limitations to due process, and the assertion was made, with which I agree, that given that there's implicit bias abounding, it infects everything we do, including what judges do, and what prosecutors do, and what police do, and what persons on the street do. But why bake in that bias into the assumptions of this new law? What was the rationale offered at the time, Senator?
It's funny you mention that. There was a case in North Florida that was cited as the impetus of this. It was after a hurricane, an elderly gentleman and his wife, and the way it was told to the legislature by the proponents of it, there was an elderly gentleman and his wife living in their trailer after a hurricane, and a man from South Carolina who was working in Florida to help with the cleanup came to the gentleman's house, and altercation ensued, and the older gentleman shot the young guy. And it was told that the older gentleman was arrested and had to go through all of these months of worried about whether he was going to be convicted, had to get lawyers and everything. Well, it turned out to be a fallacy once some reporters started looking into it later. But just the climate in the Florida legislature is the easiest law to pass is something, giving people more gun rights or tough on crime or something like that. To go more to your concern, it wasn't thought that it would be such a subjective standard when it was passed, and I voted against it, but even colleagues of mine that voted for it did not know, and it wasn't fully explained that it would be a subjective standard, and that's why we've tried to go in subsequently and at least move it to more of an objective standard, because as you've stated, that's where the racial bias comes in. That's where some of the concerns come in, because it's such a subjective standard that people can avail themselves of this, even not in a reasonable circumstance. I don't reasonably think that I should shoot someone in a movie theater because they threw popcorn at me. But if it's subjective, if I go to a subjective and did this person actually fear when the person stood up and threw popcorn, they can avail themselves. And so that's been some of the concerns that we've had and some of the changes that we've proposed to make it more of an objective standard instead of subjective.
And did the legislature recognize that all of these judgments would be made at the scene and essentially by the officer? Did they understand that what had traditionally been the prerogative of judges and lawyers in courtrooms with due process, evidentiary protections, et cetera, would now be pushed down to the investigating officer to make some kind of at least preliminary judgment about whether or not the person had reasonable, not reasonable fear, whether the person had fear at all and therefore used deadly force against an aggressing, an aggressor?
At the time, in 2005, I was the minority leader of the Florida House, and I can honestly say this wasn't a big issue. When Stand Your Ground passed, myself and two other lawyers that were in the Democratic Party, we wrote a letter. We voted against it, and only about 12 of us did. The entire Senate, bipartisan, every member of the Florida Senate voted for it. It wasn't seen as a groundbreaking piece of legislation, and it sat actually dormant and not used until you started hearing about the Trayvon Martin case. So remember, this passed in 2005, and when did you really hear about this law? After the Trayvon Martin case, and now we've seen a plethora of cases come afterwards because people are starting to avail themselves and become emboldened because they think, I got this great get-out-of-jail ticket to do my aggression. But honestly, in 2005, members did not understand the full ramifications. Non-lawyer members, because we're a legislature of a lot of people, did not understand the ramifications, and even the lawyers in the legislature didn't fully understand because it was such a new and groundbreaking piece of legislation. It was just sold on a political basis as you shouldn't have to cut and run, you shouldn't have to retreat, you shouldn't have to turn and run, and this is a way of giving your citizens a chance not to have to turn and run and get shot in the back.
Thank you, Senator. Appreciate that.
Next, we have Commissioner Timmons-Goodson, who will be followed by Commissioners Harriet, Kurzenow, Cladney, and then Commissioner Yockey.
Thank you so very much, Mr. Chair.
You're welcome.
My question is for Representative Rutherford. One of the major criticisms offered of the Stand Your Ground laws by opponents is that it so easily allows the escalation of fairly small incidents into deadly affairs. And with that in mind, I'd like to just explore with you for just a few moments your thoughts based on statements that you've made. You've said early on that at the time that the Stand Your Ground law was enacted in South Carolina, that there was no self-defense law, that laws related to self-defense were outdated and archaic, that one could not elevate, I believe you said, the use of force. In fact, the common law was what was in effect. Is that not right? In other words, the judges used the common law, applied that to the facts that came before them. Is that right?
They applied prior case law, exactly.
Okay. And that prior case law was based on common law?
That's right.
Now, you've also said that stand your ground, or the stand your ground that you support, means that people don't have to live in fear. That not elevating force doesn't make sense to you. First, I guess I want to know, ask you to explain your thought that the laws that were in effect or applied relating to self-defense prior to stand your ground law, why they were archaic. You know, what makes you say they were outdated?
Well, remember, South Carolina had no statute on self-defense, so it was simply based on your ability to articulate your self-defense or why you did something in a trial while you were on trial for whatever the given offense was. You were charged with a crime, and at that point, you could assert self-defense, but you were already charged with a crime at that point. You had no ability to tell a law enforcement officer or ask for a prior hearing, which is now called the immunity hearing, under stand your ground. If you truly defended yourself, you should have the ability, in my opinion, and stand your ground backs this up, to request that a judicial officer or a judge determine that you are absolutely right. You defended yourself, you had a right to do so, and in doing so, you should be immune from prosecution. The non-elevation of...
Let me just ask you, how does that differ from any other defendant defending themselves in response to a criminal charge filed or a civil case where a plaintiff asserts something and, you know, one is called upon to gather your resources and to defend? I mean, how is that
Your
different?
liberty is not in jeopardy in a civil case. In a criminal case, your liberty is in jeopardy. And so, for most criminal cases, if a trial is going forward on a forgery or a fraud charge, what you're saying is that I did not do this. When it's related to self-defense, and stand your ground requires that you say, I did this, and I did this for this reason. And you're asking that a judge in an immunity hearing say, what you did is reasonable or what you did is unreasonable. In the case where the gentleman was involved in the home invasion and he tried to say, I should be cleared to understand your ground, the judge sent it up. The Court of Appeals said, no, give him a hearing. The judge gave him a hearing and denied him immunity, period. It is based on reasonableness. And I'll read you 1611-420, the intent and findings.
Yeah. We could go in different directions, but I hear, and I didn't mean to cut you off, but I hear what you're saying. But you do have bond in cases that would have involved self-defense, as you would have had bond offered in other cases in South Carolina, do you not?
Yes, ma'am. And bond is based on what should be based on simply someone's, whether they're going to show back up in court, whether they're a danger. If they're charged with murder, even under the stand your ground cases, they would still have to go forward and get a bond. But at least at the bond hearing, you'd have the right, as I did in the most recent case, to say, we believe that stand your ground is going to apply in this, and have a judge listen and agree or disagree and set bond accordingly. Bonds are not meant to punish, but most often in murder cases, they do exactly that.
Okay. So as I understand it, the reason that your the existing South Carolina laws relating to self-defense were viewed as archaic is that it required an individual to go forward and to defend themselves.
To stand trial, and
Okay.
at trial, only then could you defend yourself, not prior to that point.
Okay. Second and last question. You say that stand your ground law to you means that you don't have to live in force, that It
Fear.
doesn't make sense to you that one would not be permitted to elevate force. I guess I'm left wondering, why is it not common sense that if someone comes up and pushes you, that you push them back, or if someone comes up and hits you with a fist, that you hit them with a fist? Why why does it make such sense that you could elevate the force that you use to a gun or a knife in response to being pushed or hit with a fist?
Commissioner, respectfully, I submit that you should have a right to not have people hit you with fists, that you have a right not to be pushed, that you have a right not to wait and see what the next step will be once someone hits you in the face. You should not wait to see whether you're going to be knocked out. You should have a right to pull a gun if you have one and say, leave me alone. I don't want to be bothered. And that's what the General Assembly found. We have a right to live in peace. And peace means that I'm not going to wait on you to hit me. I'm not going to wait on you to push me. I'm standing with my 2 children. I have 2 little boys. And if you're going to walk up to me and try and assault me or one of them, I'm not going to wait to see what your next step is going to be before I decide what I'm going to do. That's what the General Assembly found. And I think that's common sense.
Thank you, sir.
Commissioner Harriet, you have the floor.
Thank you, Mr. Chairman. Here's my problem with the discussion so far. It seems like a lot of what is being said here is not special to stand your ground at all, but rather could be an argument against the doctrine of self-defense in the first place. And I assume that nobody here is in favor of repealing self-defense as a basic doctrine here. Representative Rutherford, I was impressed by your discussion a little while ago about implicit bias. Let me see if I can restate it and see whether you still agree with me. The way I see it, as you put it, implicit bias is background. You know, it's involved not just in stand your ground laws, it's involved in every kind of law there can be. Including the exercise of basic self-defense. So if we're talking about a non-stand your ground state, one of the things that has to be guarded against generally is implicit bias against black males, a trigger-happy person who believes he's under attack but isn't. You know, he thinks the black male is about to attack him, but it's not true. He pulls the gun, and you know that problem's always there. And that problem's there when we talk about home invasions and general castle doctrine. And what stand your ground adds to that is simply now there's this small number of cases. I think it's important to recognize stand your ground applies on only very, very few cases. I mean, the result will turn on stand your ground in just a shockingly small number of cases. These will be the cases that don't occur in the home, do occur in some place where the person who is exercising self-defense or supposedly exercising self-defense believes reasonably that he could retreat but chooses not to. In most of these cases in public places, it's not going to be possible to retreat, and therefore stand your ground doesn't make any difference. You still have a right to self-defense. So we're talking about this tiny number of cases where the defendant or the person who is exercising or is said to be exercising self-defense knows that he can retreat but chooses not to. That's a very small number of cases. Stand your ground adds an implicit bias problem against the black male who is perceived to be attacking. But on the other hand, it helps the black male in the opposite position, the one who's actually purportedly exercising self-defense. He has to worry about implicit bias at the time of trial when the jury is second-guessing him on whether or not he could have retreated. They weren't there. And they may be more likely to find, hey, you know, the guy says that he was under attack, we don't believe him, or hey, he says he could have retreated, we don't believe him. So implicit bias is everywhere in that respect. And stand your ground doesn't add to the problem for the black male, it simply helps a different category of black male.
Absolutely.
Is that
you succinctly stated exactly what my position has been, and I agree with you. I think that a lot of these cases that have been mentioned aren't necessarily turning on stand your ground, but an officer and investigator's perception and what is self-defense anyway. and then he's saying, well, because it's stand your ground, I'm not going to arrest you, I'm not going to detain you. But it's his assertion of self-defense and using that as a...
So the second manifestation I saw of this problem where we seem to be moving between self-defense and stand your ground and not recognizing that the arguments were being made that apply to self-defense too, right. Was in the area, Senator Smith, you mentioned the detain issue in the Florida statute. But isn't that just what the basic law would be with regard to self-defense? If police officers investigate a crime and it's not a stand your ground case, it's just basic self-defense. Everybody agrees there was no ability to retreat, so stand your ground doesn't make any difference. You don't arrest someone if the police officer concludes, oh, I believe based on what I know, this was self-defense. You wouldn't arrest somebody like that, would you? You wouldn't advocate that, would you?
The concern with stand your ground, it puts the officer in a very defensive posture. Before stand your ground, I agree, you need probable cause and you would do that. But stand your ground, now the officer now has a statute that says I cannot detain, and also within that statute...
But he couldn't before, could he?
Ma'am, if I can,
on a self-defense case, you can't detain somebody if the police
within that statute, it explicitly gives a civil liability to that police department if it's found that they were detained in a stand your ground case. So it couldn't before, but that was case law and officers used prudent judgment. But now an officer has a statute, a statute that says I cannot detain, and by the way, if I detain, I might get sued. And so it affects the way that officer truly investigates. As before, he would just use investigative skills and figure out, do I have due process? Now he has this hover above his head saying, oh my God, if I use my investigative skills and I may be wrong, I have a statute particularly pointing to civil liability for me and my department. So it affects the officer's use of the investigative skills, because now we've put in statute, not just common sense and case law, but we've put in statute that you better not detain. And by the way, if you make the wrong judgment, officer on the street, your department's getting sued.
Yes, but that's exactly what should happen. You should not detain people that simply defended themselves, that are not wrongdoers. Commissioner, you're exactly right, and that turns on, in my situations, African-American males who are dealing with that implicit bias from police officers going, you know what, I'm not going to give you that benefit of the doubt. And that police officer should be sued simply because he now is detaining Trayvon Martin, should he have shot George Zimmerman, saying, well, you're a black man in a hoodie, I'm not going to give you that same defense. The police should be sued when they are detaining and arresting people that are not wrongdoers.
The third area where I saw, again, getting off track and acting as if, we're talking about stand your ground, when in fact the argument that's being made would apply to self-defense generally, was with the civil liability area. It's massively more important that, like, when people are exercising their right to self-defense, just in an ordinary case where stand your ground wouldn't be involved, you've still got the problem of mistaken self-defense. If the gun goes off and hits a third person, or they were mistaken in the first place. They shoot someone reasonably believing that they are under attack, but wrong. Right. And, I teach torts in law school. One of the cases in my book is Crevassier versus Raymond. It's not a stand your ground case. It's an old Colorado case from the early part of the 20th century, where someone exercising self-defense reasonably, but mistakenly, they end up shooting someone, and that person was not actually attacking them. The law has been that as long as you're acting reasonably, you're not liable. It doesn't strike me that we're really talking about something different here. Now, you can argue about whether or not that's good law. Maybe it should be better policy to say that you're not criminally liable for your use of self-defense, but if it turns out you made a mistake, even if it was a reasonable one, then you should be liable for civil damages. If I am not mistaken, in ancient Rome, that was what the law was. You had a right to self-defense as to criminal liability, but if you got it wrong and you shot somebody even though it was reasonable, and it turns out to have been wrong, you were civilly liable. And some people have advocated such a rule. But that's really quite detached from the basic stand your ground issue. A given state could choose to make civil liability available for mistaken use of self-defense that is nevertheless reasonable. Or they could choose not to. But it's not the core issue we're concerned with. And I think we make a mistake when we start analyzing particular state statutes here and have they been drafted the best way possible. As a federal commission, we should be more concerned with, is the concept of stand your ground a good concept or not? And, you know, if any of you have a comment on that, I'd like
Ma'am, I would disagree when you talk about the civil liability because you keep getting to reasonableness. And under prior common law and case law, even when you're talking about civil liability, you say reasonableness. But under stand your ground and stand your ground specific, you don't even get to reasonableness because it's a blanket absolution of liability. You don't even get to reasonableness. If you're asserting stand your ground, you never get to anyone determining whether you were reasonable. And me trying to defend myself against you, and I just start shooting everywhere. You don't get there because the statute written in Florida absolves you of any liability, even reckless liability.
My point is that we're a federal commission. We don't nickel and dime the state statute. If you don't like that aspect of the statute, then the Florida legislature gets to change that. But that's not the basic concept of stand your ground. The basic concept of stand your ground is different from that. If South Carolina has a different statute and a different approach to civil liability, and Virginia or Minnesota or South Dakota have different approaches to that, this is not a commission convened to fly-spec the Florida statute. That's not the core concept of stand your ground.
I think this is a commission on human rights, and if there is a statute,
civil rights.
Civil rights. If there is a statute in a state in this nation that encourages people to act recklessly, and even though it may be nickel and diming in Florida, and I would hope that Florida would change that, but if Florida doesn't have the fortitude to do the right thing by its people, I would hope that this commission would at least speak to giving Florida that fortitude to say, you know what, this statute is wrong because it encourages people to be reckless in their defending of their rights.
The Constitution doesn't actually work that way. We don't have authority to tell Florida how to deal with their civil liability. We have jurisdiction over certain limited issues.
Order here. We're talking over one another. The record's not going to be clear. But in the interest of time, if I could ask Representative Smith to just wrap up what you're saying. And Mr. Abu-Zaid, did you have anything to respond to on this? Otherwise, then I'll move on to the next commissioner. But if you have, when he's done, if you have something to say, then we'll move on to Commissioner Kurzanow in the interest of time. Mr. Representative, do you want to finish your statement? Okay. Mr. Abu-Zaid?
Yeah, I'd just like to say that I hope I wasn't implying that there's something wrong with self-defense. I actually think if self-defense was so good, we should have left it that way. And so I don't think, for me, I get the Castle Doctrine. I get why that was important. I think that's why there was a distinction made that the Castle Doctrine would empower American citizens to protect their home. But Stand Your Ground said, you know what? The castle is your entire world now. The castle is the movie theater. The castle is your child's school. There was a Broward County case where a kid got arrested for assault and battery, and I think it was in the 4th Judicial Circuit. The case was overturned because of Stand Your Ground. And so the reality is it's irresponsible law. Self-defense is great. Stand Your Ground is not.
Okay, we're going to move on to Commissioner Kurzanow, followed by Commissioner Cladney. Commissioner Kurzanow, you there?
I am. I'm here. Thank you very much. Can you hear me okay?
Yes.
Okay. I think that the impetus for this hearing largely was the Trayvon Martin case. And I just want to be sure that we have on the record, at least if one of the witnesses is aware of this, and I'm not sure which one might be aware of it, but Mr. Rutherford, do you know whether or not Trayvon Martin invoked Stand Your Ground defense?
George Zimmerman, my understanding is he did not invoke that,
George Zimmerman.
Although law enforcement would have known about the existence of it, my understanding is that George Zimmerman did not invoke it, no.
Can I answer that?
Was it part of the charge to the jury?
Yes. There are two. If I can chime in, there's two things with the Stand Your Ground. There's the procedural aspect of Stand Your Ground, which is invoking it and having the procedural hearing in front of a judge to invoke Stand Your Ground. George Zimmerman did not avail himself of that procedural aspect of stand your ground. But when you talk in Florida, stand your ground is self-defense. And within the jury instruction that was used by George Zimmerman's case and any other self-defense case in Florida, there's no separation between stand your ground and self-defense. And so although he did not avail himself of the procedural aspect of stand your ground, he certainly availed himself of the substantive aspect of stand your ground. It was used in the Trayvon Martin case.
Second, I'd like to ask, in terms of, there's been a lot of discussion about, someone shooting straight or shooting recklessly or shooting negligently. I guess I'll pose this to Mr. Rutherford, who sounds a little bit like me. I hope for your sake, very sincerely, Mr. Rutherford, you don't look like me. But let me put it this way. I'm a black male living in what is generally considered in Cleveland a high-crime neighborhood. And in the last, I'd say 3 decades, I've probably been in situations 3, possibly 4 times where I could have invoked, if it were available, a stand-your-ground defense. But what strikes me is something similar to what Justice Holmes said more than 90 years ago when he said the law does not demand detached reflection in the presence of an uplifted knife. Mr. Rutherford, in the circumstances where you've defended people invoking a stand-your-ground defense, how quickly do these circumstances evolve? I mean, when someone is attacked, do they have time to think about the consequences of their actions, or is this life and death?
In the situations where I've been involved, it has been life and death, and I think you bring about a great point, as I have failed to see the distinction between stand your ground and self-defense, except that stand your ground says that you don't have a duty to retreat outside of your home. And that is one of the biggest distinctions, and truly the only distinction, and the one I would say is archaic. I do look like you, except I'm not a black male living in Cleveland. I'm a black male living in South Carolina. And I have not had unfortunately, had to defend myself anytime recently. But I would suggest that anyone that does is simply acting on common sense and self-defense and still faced with the test of reasonableness. Reasonableness does not go out of the window based on stand your ground. And there are a number of cases where people have tried to use stand your ground procedurally and been turned down from doing so. Stand your ground was used as a jury charge in the George Zimmerman case, but it was used to say that he did not have a duty to retreat outside of his home. But again, I ask, who among us asserts that you should have to retreat outside of your home? Why are we encouraging thugs to approach people and telling people that they have a duty to retreat before they act on it? Why are we saying that people must run, retreat, turn your back? It was stated that in Florida, it said safely retreat. That was not the law in South Carolina. It was retreat. And in many other places where stand your ground was passed, what we are saying is that you have an opportunity and a duty to defend yourself, to defend others, and in acting on that, you will not be prosecuted. You will receive procedurally immunity from prosecution.
Thank you. And one last question. I heard, and I didn't know which witness it was, indicate that the UN Human Rights Commission found stand your ground incompatible with the notion of right to life. Did I hear that correctly?
Yep, that's correct.
Whoever testified to that, do you know when the Human Rights Commission, the UN Human Rights Commission, made that statement?
Yep, absolutely. It was during the review of the ICCPR. It was held in March of 2014.
So this would be the same Human Rights Commission that has those human rights and pro-life exemplars such as Russia, Saudi Arabia, Pakistan, Libya, Syria, and Uganda, correct?
Could you repeat the question, please?
Is this the same UN Human Rights Commission that has the human rights exemplars on the commission, such as Russia, Saudi Arabia, Pakistan, Libya, Syria, and Uganda?
Are you asking if those are the people that sit on the committee, or are those the people?
Yes.
No, I believe the committee was made up of, Israel, several other states, but I don't remember Russia being one of them. But it was several nations. I believe also that information could be found online.
I think it can. Thank you.
Commissioner Kursnow.
Thank you.
Commissioner Cladney.
Thank you, Mr. Chairman.
You're welcome.
My question seems to revolve around procedural due process. I don't understand this. I think it's Representative Rutherford keeps talking about people shouldn't have to be arrested. Well, in process today in criminal law, police don't have to arrest anybody. They can investigate. They can turn their information over to the district attorney. The district attorney can decide whether to charge or not. And at least that's the process in my jurisdiction. It may not be that way in South Carolina. But it seems to me, and I think this is a question for the entire panel, that when you put a police officer who is trained to be an investigator, not a decision maker, in charge of making a decision, then his investigation, once he makes that decision in his mind, is all angled toward that decision that he has made. And therefore, I assume when you have this immunity hearing, he is going to be on the witness stand defending his decision. Where in the past, the police officer, the neutral, would come to court in a preliminary hearing, which I assume would be akin to an immunity hearing, and a neutral judge would make a decision as to whether there was probable cause or there was self-defense. Although I do understand that many criminal defendants refuse to put on any case at a preliminary hearing. So if you all could discuss this kind of aspect in relationship to the law, I would appreciate it. Try and enlighten me a little.
In South Carolina, you are a preliminary hearing where a hearing is held to determine whether the case proceeds to the grand jury is not a right and can be taken away by a prosecutor who simply seeks to indict. At a preliminary hearing in South Carolina, a defendant is not available. He cannot put up any evidence. It is only put on by the state. And a law enforcement officer who arrests someone unlawfully should be sued. A law enforcement officer that arrests someone who should not have been detained or arrested should be sued anyway. I think this statute only makes it clear. It does that in Florida, doesn't necessarily do that in South Carolina. But again, procedurally, what this does is allow someone, in my case, is African-American males, to avail themselves of the judicial system in front of a general sessions judge, what people on the street would call a big court judge. I don't know if they're Supreme Court judges or circuit court judges in Florida, but they would be a general sessions judge who has the ability to give them immunity, taking that decision solely away from law enforcement, where it has been vested all up until this point. There's no one that can tell me.
But you're the one who says that the old self-defense law was like just case law. It was all over the place.
In South Carolina, yes.
I would assume that you had jury instructions explaining exactly what the elements of self-defense were.
If you did not meet with the elements of self-defense in South Carolina, you did not get a jury charge to that effect. So a judge had to determine that he would even give that charge before he would do so.
So, excuse me. So where does stand your ground then become different than self-defense? If it is different from self-defense, outside of procedurally, explain it to me. I mean, you have to be in fear of harm, and so you get to defend yourself.
Right.
And the charge to the jury is the definition of the law.
Right. Procedurally, self-defense differs from stand your ground because stand your ground is going to give you an immunity hearing. So procedurally, it differs that way. Outside of that, it differs because it takes the common law doctrine, the common law castle doctrine, and extends that to wherever you may be. You never had a duty to retreat in your home. Now that duty to retreat goes away when you're outside of your home as well. It says that you have a right to live unmolested.
You really are saying if someone starts angering me and I get angry and I throw a punch, he can take a gun out and shoot me. Is that correct?
I'm saying that if someone angers you...
Is that correct? Yes or no? Yes or no, sir? Yes or no? If I throw a punch at someone, can they take a gun out and shoot me?
Yes. You should not
Thank
throw
you.
a punch at someone.
That's fine. Thank you.
Yes. The General Assembly has consistently found in states where they've enacted this that you should have a right to live unmolested, that you should have a right to expect to be left alone with your home, your business, and your vehicle, and wherever you may stand. And this assertion that you should be able to walk around, whether it's a commissioner or anybody else, punching people in the face without them having the ability to defend themselves, to me, just does not make sense. We negate
So
the
you've
fact
never,
that
you've never been in an alcohol-fueled situation, and you've never seen a fight occur like that?
I've never been in a what?
Alcohol-fueled.
Alcohol-fueled situation?
I don't
Where
drink.
alcohol is driving the parties?
I don't drink, but I have been in a number of situations where people were fueled by alcohol and doing wrong. In South Carolina, we also allow you to carry your gun into a bar if the bar owner does not put up a sign and prohibit you from doing so. However, in doing that, we mandate that concealed weapons permit holders that are going into a bar can have absolutely no alcohol. So if a concealed weapons permit holder in South Carolina was in a bar and had a weapon on them and was, as in your scenario, punched in the face, would they have a right to defend themselves? Absolutely.
But if the gun's concealed...
Does anybody else on the panel like to comment on my query?
The bar owner would have a sign on the door saying no concealed weapons permits allowed, and the concealed weapons permit holder, as a duty by having a concealed weapons permit, must check the sign on the door before he goes in.
Here's what I'm going to do. We're technically out of time, but I want to, two commissioners, Commissioner Cladney, if you could wrap it up. I've got two commissioners who want to ask two brief questions, Yaki and Narasaki. So, Commissioner Cladney, if you could just finish your questioning, and I'll go to Commissioner Yaki, then Commissioner Narasaki, and then we'll conclude the panel.
I would just, Mr. Chairman, I'd just like to let the other panelists comment on Representative Rutherford and my question, if they could do so briefly.
This is Ahmad Abuznaid. I would just like to say that the issue here isn't concealed carry permits. The fact of the matter is, even without that provision requiring concealed carry permit holders to not drink alcohol, the gentleman could just step outside of the bar and then unload a clip into, whatever person he was deemed afraid of. So I think that, we can get lost in discussing permits and whatnot, but the issue here is stand your ground in the fact that it's
and that
unreasonable.
would be neither stand your ground nor self-defense. You cannot walk out and shoot back in. That would not be stand your ground.
But if the altercation spilled out to the exterior of the bar and you were in fear of your life...
If you're still getting beat up and assaulted outside of a bar from the inside all the way to the outside, you should probably defend yourself.
But also stand your ground doesn't require that you're beat up. So the gentleman could be walking towards your direction, yelling obscenities at you.
Why is it that we are requiring, or do we want to require?
We're going to let Commissioner Yaki ask a question, and then we'll go to Commissioner Narasaki and conclude the panel. Thank you. Commissioner?
Yes, thank you very much. I guess I remain troubled by some of what has been said here today. I think we do actually have an obligation to nickel and dime some of these statutes, because we're here because Trayvon Martin and Jordan Davis were victims of these statutes, and we're not, those people were not nickel and dimed. I'm not going to ask a question. I'm just going to make a very brief statement. Mr. Rutherford, I appreciate your passion. I understand that you believe that what you're doing is in the best interests of African Americans who live in fear of walking the streets. But what we have here is data that shows that in all states that have stand your ground, homicide rates go up rather than go down. The data shows that if you're an African American claiming stand your ground defense, you're much less likely to get it granted than if you're a white person claiming it, and if your victim is black. You talked about whether or not Trayvon Martin would be able to have used that, but Trayvon Martin is dead. And he was not able to say, I was acting in self-defense when George Zimmerman approached him. The problem with all this is that people are dying. More people are dying than would have died before. In your situation that you talked about, if someone throws a punch at me, I have the right, according to you, to take out a gun and shoot him. Now, if I think the person is going to throw a punch at me, I have the right to take out a gun and shoot him. If the person threw a punch at me and missed, and we walk outside, and I see him walking toward me, I can take out my gun and shoot him. In all these cases, someone gets hurt, someone dies, and you're essentially giving someone who is not trained like a police officer, as Mr. Cladney was saying, does not understand how to judge a situation, has not taken proficiency courses in shooting so as to minimize casualties to civilians. And yes, you're right, cops do sometimes miss and they shoot the wrong people. But for the most part, they're trained, and we have an expectation that they should be trained to not sort of spray their gun anywhere. And you're essentially giving ordinary citizens the right to draw and fire wherever they may be at any specific place and time. That's the problem with Stand Your Ground, is that the castle is no longer the castle. The question of reasonableness when someone breaks into your house is a lot different than when you're in an open theater or in an auditorium such as this. The judgments are a lot different, and the result is that someone dies. And the stats show people die. More people are dying because of this. And as great as you are as an attorney and expensive as you are as an attorney, even though you forgot your tie today, in terms of defending people who you believe were asserting their rights, and I agree that they should be able to assert their rights if it was self-defense. Stand Your Ground is different from self-defense, because the way it works, the situation in which it occurs, the environment in which it happens is much different than if you're inside your home, or if you're in absolute imminent fear of someone else taking a gun at you and the gun is out there and you have to do something. Those are the exceptions that prove the rule of the old common sense castle doctrine. But Stand Your Ground takes that and perverts that to an extent that I am concerned about, and especially for African Americans who do not get the benefit of it as white defendants do, who are the victims of it more than whites are. I think those are the things that I'm concerned about.
Thank you, Commissioner Yaki. Commissioner Narasaki, you have the last question.
Thank you. I just really want to thank all of the panelists for the discussion. It's been very illuminating, and it's clearly a very passionate subject for everyone. So my understanding, and I appreciate Commissioner Harriet's efforts to try to untangle the issue of how Stand Your Ground is different from the castle doctrine. I want to make sure I understand it correctly. So my understanding is, that it gives you more leeway to escalate. It doesn't require equal force, but you can more quickly escalate. B, you don't have to be in your home or in the vicinity of your home, so that makes it more likely that innocent bystanders, in fact, will be around and more likely to therefore be collateral damage. 3, my understanding is that there is more subjectivity to the fear that's allowed, that it's not a reasonable person standard, but in the case, so there was a case of a guy who shot a Chinese American neighbor. The Chinese American neighbor was actually going to his own home next door, and the guy who shot him said, well, I was in fear of my life because all Chinese know karate and can kill me. So that would be his subjective fear, but I hope most of us would not think that that was a reasonable person standard, meet that standard. So if this is all, so I want to ask Mr. Abu-Zeid, is this a correct understanding? And B, the argument seems to be, because we're here, the reason the Commission is looking at this is because there's a question about equal protection under the law and whether in fact these laws are victimizing African Americans or being applied differently in a way that hurts minority communities. But the argument that seems to be being made by some is that in fact it is helping African Americans. So I want to know, since you are clearly not in support of the law, where is the conflict in that? How is it that it helps? Does it help enough to change your mind?
So to your first question, that list did seem accurate, and I would just add in addition that it, Stand Your Ground eliminated the duty to safely retreat, which is what we had in Florida. And I think for people that had issues with self-defense, that would have been the change I would have advocated for. Just simply require someone to safely retreat if possible. To your second question, I think, with everything going on in Ferguson, with everything going on in the state of Florida, young black and brown men and women don't feel safe. Now, whether that is because of police brutality and excessive force, or vigilantes, or people like Michael Dunn who don't like thug or quote-unquote thug music, which is hip-hop, people are being subjected to being threats of society when they really just want to live. They really just want to prosper peacefully in their communities. Trayvon Martin was walking to his father's home. I mean, if we are to accept that in any day in today's society, a kid can get gunned down walking to his father's home simply because another man has the right to stand his ground, I think we've lost all faith in our society. I think that, the examples drawn up by the commission member about being punched in the face. Now, what would you teach your child is what I would implore folks to think about. Would you teach your child to punch back or to fire their gun off? Or do you teach your child, you know what? The person that punched you was wrong. We're a society that does not condone violence. We condemn it, and we'd like to have a peaceful society. Now, maybe that's utopian and could not exist, but I just say that we've seen it now bubble into our schools. People are in fear of their lives, and they deserve better, and we should do better.
Thank you, gentlemen, for a very engaging panel. We appreciate it. We went over a little time, but it was very informative. Yes, Senator?
Mr. Chair, just two quick things, if I can.
Quickly.
I'll be very brief. Commissioner Harold brought up a great point. There is a thin line between stand your ground and common law self-defense, and we're getting blurred in that line. My only point would be that with the invocation of stand your ground and the cases that's subsequent, you're going to see more and more of these cases. Between 2005 and Trayvon Martin, there are very few cases, but now people have in their mind, at least in Florida, that they have this great get-out-of-jail-free card. So we're working towards stopping what's coming, not what has happened. And lastly, the point that was made earlier about data collection, and if that's something that you can address, that would be tremendous, of maybe requiring these states to do data collection. Although I want other changes to stand your ground, but God bless you if you could get states to at least keep the data, and that will help your job and my job as we go forward.
Thank you, Senator. That will be an excellent recommendation. Thank you all, and we appreciate your time. So as this panel cycles off, we ask panel 2 to begin to come forward.